November 22, 1945, Dachau concentration camp. American military intelligence officers stood in a concrete room measuring 12 feet by 14, where two galvanized steel tanks rested side by side, each 6 feet square and 4 feet deep, their interiors still stained with calcium deposits and rust that no amount of scrubbing could erase. One investigator knelt and ran his gloved hand along the inner wall of the left tank, feeling the pitted surface where ice had scraped metal for 3 years, while another photographed the drainage valves and the wooden platform where observers once stood with clipboards, stopwatches, and rectal thermometers calibrated to track the mathematics of death degree by agonizing degree. The room smelled of disinfectant and old water, but beneath that sterile odor lay something the nose could not name, the residue of 280 to 300 human beings lowered into freezing liquid and held there until their hearts stopped, or their screams fell silent. A sergeant lifted a metal file box from a shelf in the adjacent office and set it on a camp desk with a sound like a judge's gavel, then opened the lid to reveal a stack of typed logbooks bound in gray linen, each page dense with columns headed Versuchsperson, Wassertemperatur, Rektale Temperatur, Zeit bis Kollaps, and the bureaucratic language of hypothermia rendered as cleanly as a grocer. I receipt. An American medical officer pulled the top volume and read aloud the entry for November 9, 1942, where Subject 37 had been immersed at 0400 hours in water, chilled to 2.7 degrees Celsius, his core temperature monitored every 15 minutes until it reached 27.8 degrees Celsius at 0638 hours, at which point cardiac arrest was noted and the body removed for autopsy. There were no names, only numbers, and no mention of consent, refusal, or the fact that Subject 37 had been a Polish political prisoner with a wife and 2 children who would never learn where or how he died. The officer closed the logbook and looked at his colleague, a psychiatrist named Leo Alexander who had spent the previous 6 months traveling across liberated Europe collecting documents, interviewing survivors, and piecing together the architecture of medical atrocity. Alexander said nothing for a long moment, then spoke in a voice that seemed to come from a great distance. They recorded everything, he said. Every temperature drop, every convulsion, every moment of agony, as if precision could transform murder into science. The sergeant asked whether these records would be used as evidence, and Alexander nodded slowly. They will be, he replied. But first the world must understand what it is looking at, because without a clear standard, without a rule that says consent is not optional, these men will argue that what they did was no different from experiments conducted anywhere else. And that argument, Alexander continued, almost worked. In the months after liberation, Polish resistance groups had sent reports to Allied intelligence describing medical experiments in camps across occupied territory, documents that detailed injections, surgeries, freezing protocols, and high-altitude chambers. But those reports were filed away with notes like unconfirmed, needs verification, possibly exaggerated by traumatized sources. British and American officials who reviewed the early testimonies found them difficult to believe, not because the cruelty was unimaginable, the century had already taught that lesson, but because the scale and systematization seemed too organized, too institutional, too clinical to be real. A memo dated March 1945 from an intelligence liaison officer in London acknowledged that allegations of systematic human experimentation had been received, but recommended caution in presenting such claims without corroborating physical evidence, as wartime propaganda often amplified rumor into fact. The skepticism was not malicious, but it was fatal to urgency. By the time American forces liberated Dachau in late April 1945, thousands of pages of evidence sat in file rooms across 3 capitals, waiting for someone to take them seriously. On May 13, 1945, at Dachau, an interrogator sat across a wooden table from a man named Anton Pacholeg, a Czech prisoner who had survived the camp and now spoke in clipped, factual sentences about what he had seen. Pacholeg described the cold water experiments conducted by SS Hauptsturmführer Dr. Sigmund Rascher, explaining that prisoners were brought from their barracks without warning, stripped, and placed in tanks filled with ice water, while Rascher and his assistants measured their body temperatures through rectal thermometers and observed the progression of hypothermia from shivering to unconscious, to death. The interrogator asked how many men had been used, and Pacholeg estimated between 280 and 300. with roughly 80 to 100 dying either in the tank or shortly after removal. The interrogator wrote down the numbers, underlined them twice, and asked whether any of the subjects had volunteered. Pacholeg looked at him as if the question made no sense. "Volunteer," he said. No one volunteered. They were taken. But there was another voice that would haunt the courtroom a year later. Walter Neff, an Auschwitz prisoner who had been transferred to Dachau and forced to serve as Rascher's medical orderly, testified at the doctor's trial about one experiment that lasted more than 5 hours. He described 2 Russian officers who were placed in a tank of ice water, their body temperatures dropping minute by minute while Rascher stood on the platform above them with a stopwatch and a chart. Neff recalled that one of the men said to the other, "Comrade, please tell the officer to shoot us," and the other replied that he expected no mercy from this fascist dog. The 2 shook hands and said, "Farewell, comrade," and a young Polish prisoner translated the words for Rascher, though he softened the tone to avoid angering the SS doctor. Rascher walked to his office, and the young Pole immediately tried to chloroform the 2 victims to spare them further suffering, but Rascher returned within seconds, threatening everyone in the room with his pistol. The test lasted at least 5 hours before death supervened. Neff's testimony was typed, recorded, and entered into the trial record as Prosecution Exhibit 89, and it became one of the most cited pieces of evidence in the case, because it did what numbers alone could not. It gave voice to the moment when human beings realized they were no longer patients or prisoners but material, and that no plea would stop the clock or empty the tank. That testimony, like dozens of others, was typed, filed, and sent up the chain of command. But for months it remained one more horror in a landscape dense with horrors, competing for attention with the liberation of extermination camps, the hunt for high-ranking Nazis, and the political calculus of occupation. It was not until the autumn of 1945, when prosecutors began assembling the case for what would become the doctor's trial, that the full scope of the medical experiments emerged from the files and demanded a legal response. Even then, doubt lingered in the form of a defense argument that would prove both predictable and dangerous. The defense would claim there had been no law, and for a moment the world would have to admit they were right. December 9, 1946, Courtroom 600 in the Nuremberg Palace of Justice, Brigadier General Telford Taylor rose to deliver the opening statement for the prosecution in United States of America versus Karl Brandt et al., and his first words carried no ambiguity. The defendants in this case are charged with murders, tortures, and other atrocities committed in the name of medical science, he said. The victims of these crimes are numbered in the hundreds of thousands. A handful only are still alive. A few of the survivors will appear in this courtroom. But most of these miserable victims were slaughtered outright or died during the course of the tortures to which they were subjected. He paused and looked at the dock where 23 men sat in 2 rows, some in civilian suits and others in worn military tunics, physicians and administrators who had once commanded budgets, staff, and the power to decide who lived and who became raw material. For the most part, Taylor continued, they are nameless dead. To their murderers, these wretched people were not individuals at all. They came in wholesale lots and were treated worse than animals. Taylor's voice filled the chamber, measured but unyielding. They were 200 Jews in good physical condition, 50 gypsies, 500 tubercular Poles, or 1,000 Russians. The victims of these crimes are numbered among the anonymous millions who met death at the hands of the Nazis, and whose fate is a hideous blot on the page of modern history. The judges, 3 American jurists appointed by the military government, listened without expression while court reporters typed every syllable and photographers captured the scene for newspapers that would carry it across continents. The prosecution team had assembled more than 1,500 documents and planned to call 85 witnesses, building a case that would map the experiments from conception through approval, execution, documentation, and defense. But even as Taylor spoke, the defense was preparing an argument that would force the Allies to confront a gap in the law itself. 2 weeks into the trial, defense counsel Robert Servatius stood and addressed the tribunal with a voice that sounded less defiant than matter-of-fact. He argued that his clients had operated within the legal framework of their time, and that no international statute or treaty had established a universal standard for voluntary consent in medical research. The experiments, he said, were conducted under German law, which did not prohibit such procedures on prisoners or those deemed enemies of the state. He pointed to historical examples of research in other nations where consent had been ambiguous or absent, suggesting that to punish German doctors for practices tolerated elsewhere would be to apply a retroactive and selective morality. Servatius's argument was more than rhetoric. It was anchored in a genuine absence. Before 1947, no binding international code had codified the principle that voluntary informed consent was absolutely essential for human experimentation. Professional guidelines existed in some countries. Ethical debates had occurred in medical journals, and some researchers honored consent as a matter of personal integrity. But none of that constituted enforceable law. The Hippocratic tradition spoke of doing no harm, but it did not define the boundary between therapeutic intervention and experimental coercion. The defense had found a legal shadow and was determined to stand in it. Judge Harold Sebring leaned forward and addressed Servatius directly. "Counsel, you are suggesting that absent an explicit international prohibition, these acts, however brutal, fall outside the jurisdiction of this tribunal?" Servatius nodded carefully. "Your Honor, I am suggesting that the law as it existed at the time did not prohibit these procedures. My clients may have violated moral sensibilities, but morality is not law. Law requires codification, and there was none." The prosecution knew the argument was coming, and they knew it would worry the judges. That worry was what brought Leo Alexander back to Nuremberg. Alexander had spent the summer of 1945 racing across liberated Germany, interviewing survivors, photographing equipment, and cataloging crimes that most people could not yet fully believe. By July 10, 1945, he had completed a 228-page report on Rascher and the Dachau hypothermia experiments, documenting the protocols, the victims, the data collection methods, and the institutional network that made it possible. Over the following months, he produced more than 1,500 pages of evidence, tracing the experiments on high-altitude exposure, malaria, sulfanilamide, seawater survival, sterilization, and skeleton collection. He attended autopsies, studied lab notes, and pieced together chains of command from invoices, meeting minutes, and signed approvals. He was not only a witness but an architect of the case, translating medical horror into legal language and doing it with a precision that left no room for the defense to claim ignorance or accident. But precision alone would not be enough if the law itself was silent. On a cold afternoon in February 1947, Alexander sat in a small office near the courthouse and drafted a memo that would become the skeleton of what history now calls the Nuremberg Code. He titled it simply Memorandum and wrote it in the form of 6 points, later expanded to 10 by the tribunal, outlining the conditions under which medical research on human beings could be considered ethically and legally permissible. The first point was direct and uncompromising. The voluntary consent of the human subject is absolutely essential. He continued, explaining that this meant the person must have legal capacity, must be free from coercion, and must possess sufficient knowledge to make an informed decision about participation. He wrote that the duty to secure this consent could not be delegated, that it rested personally on every investigator, and that without it the entire structure of research collapsed into exploitation. He was not inventing a principle. He was naming what had been implicit in the testimony of every survivor who said, "I did not choose this." Alexander's memo reached the prosecution on April 17, 1947, and it arrived at a critical moment. The trial had dragged through months of evidence, and the defense continued to press the claim that the experiments, however brutal, did not violate any law that existed at the time they were conducted. The judges were American, trained in common law traditions that valued precedent and statutory clarity, and they were visibly uncomfortable with the idea of convicting doctors for violating a standard that had never been written down. The prosecution needed to show that the principle of consent was not new, that it had roots in medical ethics, moral philosophy, and the lived experience of patients who had always understood the difference between healing and harm. But more than that, they needed to make it law. The evidence provided the lever. In late April 1947, the prosecution introduced Prosecution Exhibit 386, a folder containing photographs from the Dachau experiments. The images showed men submerged in steel tanks, their faces twisted in agony, ice floating on the water's surface, and technicians standing beside them with clipboards and stopwatches, as if they were monitoring the temperature of a chemical reaction rather than the death of a human being. One photograph depicted a prisoner being pulled from the water, his skin mottled blue and white, his limbs rigid, his eyes open but unseeing. Another showed a rewarming apparatus, a tub of scalding water into which hypothermic victims were plunged in an attempt to restore circulation, a method that often caused cardiac arrest and was documented in Rascher's logs as trial and error. The courtroom fell silent. A prosecutor held up one of the photographs and addressed the tribunal. "This is subject 53, he said. We do not know his name. According to the logbook, he was immersed at 0300 hours on December 12, 1942, in water chilled to 3 degrees Celsius. His rectal temperature dropped to 28 degrees Celsius over the course of 2 hours and 14 minutes. He lost consciousness at 0441 hours. He was removed at 0512 hours and pronounced dead at 0520 hours. There is no record of consent. There is no record that he was told what would happen. There is only the number 53 and the curve of his dying." Judge Harold Sebring leaned forward and asked the question that would change everything. "Counsel, was there any legal or ethical framework in place at the time of these acts that would have prohibited what is shown in these documents and photographs?" The prosecutor paused, then answered carefully. "Your Honor, there was no codified international law. But the principle that underlies such a law, the principle that a human being cannot be used as a means without consent, is not new. It is inherent in the concept of human dignity. What we are asking this tribunal to do is not to invent a rule, but to recognize one that has always existed and to write it down so that no one may ever again claim ignorance." Sebring nodded slowly. "Then write it," he said, "and we will consider it." That was the turn. Even before the Nuremberg Code was written, its spirit already echoed through the courtroom, shaping how judges heard testimony and how prosecutors framed evidence, transforming each document and photograph into proof not just of cruelty, but of a violation so fundamental that the law had to catch up to the human conscience. The tribunal did not yet know the rule it would create, but it understood that silence was no longer an option. The Nuremberg Code, though not yet born, was already influencing the post-war era, becoming the retroactive lens through which every experiment, every denial, every plea would be judged. August 19, 1947, courtroom 600 in Nuremberg. Judge Walter Beals took his seat at the center of the tribunal bench, flanked by Judges Harold Sebring and Johnson Crawford, and the room held its breath because after 140 days of testimony, 85 witnesses, and nearly 2,500 documents, the verdict was about to rewrite the relationship between science and the human beings it claimed to serve. Beals began to read in a voice that carried no emotion but left no room for ambiguity. "The great weight of the evidence before us is to effect that certain types of medical experiments on human beings, when kept within reasonably well-defined bounds, conform to the ethics of the medical profession generally." He paused, then continued. "The protagonists of the practice of human experimentation justify their views on the basis that such experiments yield results for the good of society that are unprocurable by other methods or means of study. All agree, however, that certain basic principles must be observed in order to satisfy moral, ethical, and legal concepts." Then he named them. Point 1. The voluntary consent of the human subject is absolutely essential. The phrase landed like a verdict within the verdict, simple and final. Beals elaborated, explaining that this meant the person involved must have legal capacity to give consent, must be so situated as to be able to exercise free power of choice without the intervention of any element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion, and must have sufficient knowledge and comprehension of the elements of the subject matter involved as to enable him to make an understanding and enlightened decision. He continued through the remaining 9 points, each one mapping a principle that the Dachau logbooks and Rascher's photographs had violated by design. Point 2. The experiment should be such as to yield fruitful results for the good of society, unprocurable by other methods or means of study, and not random and unnecessary in nature. Point 3. The experiment should be so designed and based on the results of animal experimentation and a knowledge of the natural history of the disease or other problem under study that the anticipated results will justify the performance of the experiment. Point 4. The experiment should be so conducted as to avoid all unnecessary physical and mental suffering and injury. Point 5. No experiment should be conducted where there is an a priori reason to believe that death or disabling injury will occur, except perhaps in those experiments where the experimental physicians also serve as subjects. Point 6. The degree of risk to be taken should never exceed that determined by the humanitarian importance of the problem to be solved by the experiment. Point 7. Proper preparations should be made and adequate facilities provided to protect the experimental subject against even remote possibilities of injury, disability, or death. Point 8. The experiment should be conducted only by scientifically qualified persons, and the highest degree of skill and care should be required through all stages of the experiment of those who conduct or engage in the experiment. Point 9. During the course of the experiment, the human subject should be at liberty to bring the experiment to an end if he has reached the physical or mental state where continuation of the experiment seems to him to be impossible. Point 10. During the course of the experiment, the scientist in charge must be prepared to terminate the experiment at any stage, if he has probable cause to believe, in the exercise of the good faith, superior skill, and careful judgment required of him, that a continuation of the experiment is likely to result in injury, disability, or death to the experimental subject. Together, the 10 points constituted what the tribunal called permissible medical experiments, but history would give them a sharper name: the Nuremberg Code. Leo Alexander sat in the gallery and watched as the judges read the principles he had drafted 6 months earlier, expanded and refined but still anchored in the sentence he had written first. The voluntary consent of the human subject is absolutely essential. Those 9 words answered every defense claim that the law had been silent. The law had not been silent. It had been implicit in every plea, every refusal, every body pulled from a tank of ice water. Now it was explicit. The verdicts followed, and the courtroom listened in silence. Judge Beals read the names one by one, deliberate and inexorable. Karl Brandt, Military Tribunal. I has found and adjudged you guilty of war crimes, crimes against humanity, and membership in an organization declared criminal by the judgment of the International Military Tribunal, as charged under the indictment heretofore filed against you. For your said crimes on which you have been and now stand convicted, Military Tribunal, I sentences you, Karl Brandt, to death by hanging. Brandt, Hitler's personal physician and Reich Commissioner for Health and Sanitation, stood without expression as the sentence was read. 6 others would join him at the gallows, including Victor Brack, Rudolf Brandt, Karl Gebhardt, Joachim Mrugowski, Waldemar Hoven, and Wolfram Sievers. 5 defendants received life imprisonment and 4 were sentenced to terms ranging from 10 to 20 years. 7 were acquitted, though the acquittals rested on narrow evidentiary grounds rather than moral exoneration. On June 2, 1948, the 7 condemned men were led into the execution chamber at Landsberg Prison in Bavaria, where American military personnel prepared the gallows. Karl Brandt was defiant to the end. As he stood on the scaffold with the hood over his head, he continued to speak, denouncing what he called political revenge and claiming hypocrisy from a nation that had dropped atomic bombs on Hiroshima and Nagasaki. The executioners told him his time was up, but Brandt refused to stop and the hood was placed over his head while his voice was still audible. Then the trap dropped, and the first chapter of the doctor's trial closed with 7 bodies and 10 principles that would outlive every defendant and every judge. But the longer sentence, the one that would bind every researcher from that day forward, was written in those 10 points. The Nuremberg Code did not end unethical research. It would take decades and further scandals before its principles were fully institutionalized, but it created a foundation that could not be ignored. In 1964, the World Medical Association adopted the Declaration of Helsinki, which expanded the Nuremberg Code by recognizing the need for surrogate consent when subjects lacked capacity, a provision the original code had inadvertently omitted. The Declaration of Helsinki became the backbone of international research ethics, updated continuously to address emerging challenges in clinical trials, genetic research, and health data. In 1979, the United States National Commission for the Protection of Human Subjects issued the Belmont Report, which transformed consent from a legal shield into a moral imperative grounded in respect for persons, beneficence, and justice. The Belmont Report directly cited the Nuremberg Code and the Declaration of Helsinki as foundational texts, acknowledging that the principles born in a courtroom in 1947 had become the grammar of ethical research worldwide. A researcher reading the Belmont Report today will find language that echoes Judge Beale's. Respect for persons incorporates at least two ethical convictions, the report states. First, that individuals should be treated as autonomous agents, and second, that persons with diminished autonomy are entitled to protection. Voluntary consent is not merely a procedural requirement, but a recognition of human dignity, the same principle that Alexander had written into his 6-point memo and that the tribunal had codified into law. Today, every research protocol involving human subjects must pass through institutional review boards that apply standards rooted in Nuremberg's 10 points. Informed consent forms, risk assessments, and the right to withdraw are not courtesies, but legal and ethical requirements enforced by federal regulations, professional codes, and international treaties. The code influenced the development of good clinical practice guidelines, the common rule governing federally funded research in the United States, and the ethical frameworks of institutions from universities to pharmaceutical companies. It became the invisible architecture of bioethics, present in every consent signature and every IRB meeting, a permanent answer to the question of whether science can do whatever it wishes. The answer, written in the voice of judges who had seen the photographs and read the logs, is no. Even experiments that preceded the formal writing of the code were later judged and remembered in its light, making it the retroactive standard by which the world learned to say never again. The Nuremberg Code became the lens through which the post-war era reinterpreted the entire cycle of atrocities, transforming scattered testimonies and reports into a coherent ethical demand that no silence could erase. It did not merely respond to the past. It bound the future, ensuring that every doctor, every investigator, every institution would from that moment forward operate under a rule that consent is not negotiable. The survivors made sure of that. Eva Moses Kor, who along with her twin sister Miriam was subjected to Josef Mengelé's brutal experiments at Auschwitz, spent decades speaking to medical students, researchers, and the public about what it meant to be used as a human guinea pig. She described being placed naked in a room with her sister for 6 to 8 hours at a time, measured and studied with no explanation, no choice, and no escape. It was unbelievably demeaning, she said in testimony recorded decades later. We were alive for one reason only, to be used in experiments. Kor founded Candles, Children of Auschwitz Nazi Deadly Lab Experiment Survivors, in 1984, to locate other Mengele twins and to ensure that their experiences became a permanent warning against research without consent. By 1985, Candles had reconnected 122 individual twins living across 10 countries and 4 continents. In 2011, Kor spoke at the University of Texas Health Science Center in San Antonio, addressing a room full of medical students and faculty. She stood at the podium, a woman in her 70s with a voice that carried both pain and resolve, and told them what Mengelé's laboratory had taught her about the necessity of informed consent. You must understand, she said, that the moment a doctor believes he has the right to decide for another human being what will be done to their body, medicine ceases to be healing and becomes domination. The audience sat in silence, and several students later wrote that Kor's testimony made the Nuremberg Code real in a way that no textbook ever had. Kor's experience spoke to the importance of modern-day requirements for protection of human research subjects and informed consent, requirements that trace their lineage directly back to Nuremberg. Her voice, like those of hundreds of other survivors documented by the Claims Conference on Jewish Material Claims against Germany, served as a permanent reminder that the Nuremberg Code was not abstract philosophy, but a response to real people who suffered in rooms where their refusals were ignored and their screams were recorded as data. But the Nuremberg Code alone did not prevent further violations. In 1972, a journalist named Jean Heller broke the story that would shock the United States and prove that even nations that prosecuted Nazi doctors were capable of their own atrocities. The Tuskegee syphilis study, conducted by the United States Public Health Service from 1932 to 1972, involved 600 low-income African-American men, 400 of whom were infected with syphilis. The men were initially told that the experiment would last only 6 months, but it continued for 40 years. After funding for treatment was lost, the study was continued without informing the men that they would never be treated. None of the infected men were treated with penicillin, despite the fact that, by 1947, the antibiotic was widely available and had become the standard treatment for syphilis. The study continued under numerous public health service supervisors until 1972, when a leak to the press resulted in its termination on November 16th of that year. By then, 28 patients had died directly from syphilis, 100 died from complications related to syphilis, 40 of the patients' wives were infected with syphilis, and 19 children were born with congenital syphilis. The 40-year Tuskegee study was a major violation of ethical standards and has been cited as arguably the most infamous biomedical research study in United States history. The revelation was devastating not only because of the suffering it exposed, but because it proved that the Nuremberg Code, though written into international law, had not been integrated into the daily practice of American medicine. In the period following World War II, the revelation of the Holocaust and related Nazi medical abuses had brought about changes in international law. Western allies had formulated the Nuremberg Code to protect the rights of research subjects. In 1964, the World Medical Association's Declaration of Helsinki had specified that experiments involving human beings needed the informed consent of participants. In spite of these events, the protocols of the Tuskegee study were not re-evaluated according to the new standards, even though whether or not the study should continue was re-evaluated several times, including in 1969 by the CDC. United States government officials and medical professionals kept silent, and the study did not end until 1972, nearly 3 decades after the Nuremberg trials. Writer James Jones said that the physicians were fixated on African American sexuality and believed that African Americans willingly had sexual relations with infected persons, although no one had been told his diagnosis. Due to the lack of information, the participants were manipulated into continuing the study without full knowledge of their role or their choices. The Tuskegee study revealed that blind reliance on the Nuremberg Code and the Declaration of Helsinki was no longer going to suffice. It was against this backdrop that Congress resolved to act. Numerous hearings and multiple spirited discussions later, an agreement was struck to constitute the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research. The outgrowth of a retreat held at the Smithsonian Institution's Belmont Conference Center, the Belmont Report laid out a principled analytical framework to guide the resolution of ethical problems arising from research involving human subjects. Durable and ever-present, the Belmont Report, which is the foundational document that reset the ethics of human subject research, must now reckon with all important novel issues of the day that could not have been foreseen by its drafters. On September 30, 1978, a month before its disbandment, the Commission issued the Belmont Report, and it directly cited the Nuremberg Code and the Declaration of Helsinki as foundational texts. The report articulated 3 core principles: respect for persons, which incorporated at least 2 ethical convictions. First, that individuals should be treated as autonomous agents, and second, that persons with diminished autonomy are entitled to protection. Beneficence, which required researchers to maximize possible benefits and minimize possible harms. And justice, which demanded that the benefits and burdens of research be distributed fairly. The Belmont Report transformed consent from a legal shield into a moral imperative, and its influence spread rapidly. In 1974, the United States passed the National Research Act, which created the National Commission and mandated the establishment of institutional review boards to review all federally funded research involving human participants. In 1991, 17 federal agencies adopted the Common Rule, codifying informed consent requirements that echo the language Judge Beals read on August 19, 1947. The voluntary consent of the human subject is absolutely essential. Spring 2024, a university institutional review board convened in a conference room to evaluate a proposed clinical trial involving a new chemotherapy protocol, and the first question on the standard form asked whether informed consent procedures met federal requirements under 45 CFR Part 46, the Common Rule, a regulation rooted in principles drafted in a Nuremberg courtroom 77 years earlier. The committee chair, a professor of bioethics, reminded the assembled researchers that voluntary consent was not a formality, but the foundation of ethical research, and that no scientific gain could justify coercion or deception. One of the younger investigators asked why the rule was so absolute, and the chair paused before answering. Because once, she said, doctors filled tanks with ice water and lowered human beings into them without asking. And we swore that the world would never pretend that silence was the same as permission again. That institutional review board, like thousands of others in universities, hospitals, and research centers across the globe, exists because the Nuremberg Code transformed ethical philosophy into enforceable law. Every consent form signed by a patient enrolling in a clinical trial, every risk assessment conducted by an ethics committee, every right to withdraw guaranteed by federal regulation, carries the DNA of that Nuremberg sentence. But what about the data themselves? Could they be used? In May 1990, Robert Berger, a cardiac surgeon at Harvard Medical School, published an analysis in the New England Journal of Medicine that answered that question definitively. On analysis, he wrote, "The Dachau hypothermia study has all the ingredients of a scientific fraud, and rejection of the data on purely scientific grounds is inevitable." Berger's review revealed that Sigmund Rascher had been attempting to validate a nonsensical theory proposed by Heinrich Himmler, that he failed to document crucial information, and that some of his findings were so unbelievable that they raised suspicions of fabrication. Berger expressed astonishment that contemporary researchers would even consider such severely flawed data credible. In summary, Berger wrote, "The basic information essential for documenting an orderly experimental protocol and evaluating the results is not provided. We know enough, however, to conclude that the methods of study were clearly defective." A comprehensive analysis conducted by Leo Alexander after the war had revealed that many variables were not assessed or considered during the experiments, and that there were no measurements of cardiac activity and no measurements taken during immersion in cold water. The data were not merely ethically tainted, they were scientifically worthless. The mathematics of death offered no pathway to healing, no insight that could justify the suffering, no knowledge that could redeem the crime. What remained was the code, and the principle that science without humanity is dominion, not discovery. Telford Taylor, in his closing argument on July 14, 1947, had predicted this. He said, "The mere punishment of the defendants, or even of thousands of others equally guilty, can never redress the terrible injuries which the Nazis visited on these unfortunate peoples. For them it is far more important that these incredible events be established by clear and public proof, so that no one can ever doubt that they were fact and not fable, and that this court, as the voice of humanity, stamped these acts and the ideas which engendered them as barbarous and criminal." The tribunal did exactly that. On a steel table in Dachau, next to two rusting tanks, a box of logbooks sat under lock and key in a military archive. No longer evidence in a trial, but a permanent record of what happens when medicine forgets that every number was once a name, every data point once a person, every experiment once a choice. The Nuremberg Code ensured that from August 19, 1947 forward, consent would always be the first question, the essential question, the question that no doctor could evade by claiming the law had been silent. The law was no longer silent. It spoke in 10 points, and it has not stopped speaking since. The title's promise is thus delivered. Allies ignored Nazi consent violations, filed reports as unconfirmed, and allowed skepticism to delay action, until the Nuremberg Code rewrote medical ethics, transforming a courtroom verdict into a global standard that binds every researcher, every institution, every nation that claims to practice medicine as healing rather than exploitation. The Nuremberg Code did not end unethical research, but it ended the excuse that no one knew where the line was. The line is drawn. It is drawn in the voices of survivors who said, "I did not choose this." It is drawn in the photographs of men dying in ice water while technicians took notes. It is drawn in the 10 points that Judge Beals read on August 19, 1947. And it is drawn in every consent form, every IRB meeting, every researcher who pauses before beginning an experiment and asks the only question that matters. Did they say yes?